welcome back to the show. This is an extended version of Good Morning Ghana, and we're going to have a holiday special this morning. And it's a one-on-one with Professor Kwaku Azar, popularly known as Kwaku Azar. I'm sure a lot of you have not seen him, but you've read a lot about him, especially on social media. Good morning, Prof.
Good morning, Randy. Thanks for having me here. It's
a
pleasure.
Right. I'm grateful as well. Before we go on, let me say happy birthday to you, Georgina Sechiwa, also known as Kukwa Mahama. You're a midwife. Today's your birthday, so happy birthday to you, Georgina Sechiwa, and it's from your husband, Dallas Williams. So happy birthday to you, Kukwa Mahama, the midwife. Now, Prof, we know that you reside in Florida. So why are you here?
Well, you also know that I'm a Ghanaian, yes. And so I'm here because this is home. Okay. And I live in Florida, I work there, but it doesn't take anything away from the fact that this is home.
You hold a Ghanaian passport?
Yes, absolutely.
You do?
I always travel on my Ghanaian passport when I'm coming to Ghana. Yes.
Okay. You have a dual citizenship?
Yes. No, I don't have a dual citizenship card.
Yes.
Because I went to court, and the court declared that nobody should be compelled to carry a dual citizenship card. It's optional if you want to.
Now, explain that bit.
The card, they had the dual citizenship card.
Yes.
And it's an optional thing if you want to, because all you need is your Ghanaian passport or a Ghana card.
So you're saying that the court says that if you hold a Ghanaian passport, you really don't need
the dual citizenship.
Unless you want to have it.
Unless you want to have it. But okay. I wouldn't.
So why did you go to court?
Because they were compelling it.
Yes.
It was one of a number of reliefs that I sought.
What was your reason? Why did you think that people should not be compelled to have it?
Because there's nothing like a dual citizenship card. Ghana can control Ghanaian citizenship. Other countries control their own citizenship. So Ghana cannot give you a card which says you are a citizen of another country. In their capacity as what? How would they even verify whether I'm a citizen of another country or not? So that is biting too much and asking us to give them $200 that they don't deserve. And, if people want to buy it, I said, fine, but don't compel people who already have a passport.
And the Supreme Court agreed with you?
The Supreme Court agreed with him, yes.
Okay.
Yes.
All right. So, Prof, let's come back a bit to the basics. A lot of people know you as Kwaku Azar, Professor Kwaku Azar. Who are you?
Well, like you said, I'm Kwaku Azar. Now, when I was still in high school or secondary school those days.
Which school?
St. Augustine's.
Okay.
1 to 5.
Okay.
But from 1 to 3, we had a French master, Monsieur Ba. And Monsieur Ba had problems saying Asari.
Okay.
So to him, Asari was as-a. So that's Kwaku Azar.
Oh, Kwaku Azar.
Yeah, Kwaku Azar, yes.
So that's what brought about a Kwaku Azar.
That's what it is.
Okay.
That's what it is.
Okay.
So, if you talk to anybody from St. Augustine's, they'll be able to explain it to you very easily.
Which year?
This is 70s.
So when did you leave Augustine's?
I left Augustine's in 77 or so to St. Peter's.
Okay.
In our days. Yes. Okay. In our days, St. Peter's, Nabrongo Secondary, and I believe New Jordan were the only 3 schools that were offering accounting at the A level.
Okay.
And I wanted to do accounting at the A level. Augustine's did not do accounting, and so I had to go somewhere else, and I went to St. Peter's. And from St. Peter's, I came to University of Ghana.
So you are Legon?
Yeah, I was at Legon Commonwealth Hall.
Okay.
F20 Commonwealth Hall.
Okay. What do you study? What do you read at Legon?
Business administration.
Okay. So you left Legon which year?
I left Legon in 82.
And what happened?
And then I went to, actually I left Legon in 82. I did my service at Legon. I was teaching finance in the School of Administration. And then after that, I went to the U.S.
That was during the famine.
That was during the famine, during the carrying of the cocoa, during the aluta that we did at Tech that culminated in the closing down of the university. So when I was leaving, the university was closed down. And I went and I did my master's and PhD and other things, and here I am today.
So you left for the States in 1983?
Yes.
Whoa. Okay. Were you involved in student politics when you were
From the background, yes,
Okay.
very much so.
Okay.
That's what I was saying. I was actually at UST when they sent the busload of PDCs to come and attack us. And I was very close with Atta Kennedy and Asamoah Boateng and Dan Botwe and all these other guys. They all know me. We used to meet at my home in Adabraka.
Okay.
They
lived at Adabraka?
Yeah, yes. We had a choba, and then they'll come as if we are eating, and then we'll be planning.
You speak Ga?
I speak Ga more fluently than she.
Oh, okay.
Yeah.
Okay, I see. So you're an Adabraka boy.
I'm an Adabraka boy.
Which
yes.
part of Adabraka?
Kojo Thompson Road.
Okay. The road from Tudu.
Yeah, well, yeah.
The main road from Tudu.
Yeah,
Okay.
Tudu, but then
You get
you
into
know where
Adabraka?
the old Park Cinema is?
Yes.
Yeah, I'm just by that old Park Cinema.
Okay. Okay. All right. Okay. So you went to the States. You did your master's in the States. Did your PhD in the States. How did you become a lawyer? Where from the issue of law?
Well, accounting, in a sense, is law, because accounting is the law of how businesses report on their operations. And how they should do it is set by standards, and accountants follow that standard. So they have laws, more or less, accounting laws. It's not law that is written by parliamentarians or law that is written by districts, but it's law that is written by some standard setters, and then the accountants follow that. So I've always been fascinated by law. When I was a student at Legon, I did all kinds of law as part of the business administration program. I was a student of Kwame Ahoy. I was a student of Professor Mills. I was a student of Dr. Botwe, Professor Botwe. And around 2006 or so, I actually got a law degree and got called to the Florida bar.
How difficult was that?
Very easy. I mean, it's not like Ghana where trying to be a lawyer is almost an impossible task, I did my exam. I got admitted to a school. I got my JD. I registered with the Bar Association to take the exam. I took the exam, I passed, and I became a lawyer.
Okay. So you're called to the Florida bar.
Yes.
You can practice anywhere in the States.
No, you can practice in Florida.
Okay.
Because, you see, Florida is treated as an autonomous state.
Okay.
And so I'm certified to practice in Florida, but that's about it. If I go outside of Florida, I would need permission to practice there.
Permission in what way?
From the state bar.
So let's say if you're moving from Florida to New York and you want to practice in New York, what do you have to do?
Well, then I will read the New York laws. I mean, there will be some exams that I may have to take.
Okay.
Some states have reciprocity, so it varies.
Is it because there are differences in some of the laws?
Yeah, there are differences in the state law. Each state has its own law.
Okay.
And so moving to another state, I mean, the basics of how you research the law and so on, those are going to be the same. But then substantive law may be different. And so they may require you to do a couple of things before they allow you to practice in that state.
Is there anything like a program or a certification that makes you practice anywhere in the States?
No, there's no such thing.
There's no such
it's
thing.
State by state.
So how do you appear before, say, the Supreme Court of the United States?
Well, you learn federal law.
Okay.
So federal law is different from state law.
Yes.
So, I mean, federal law is the easiest because it's just the same for the whole country. State law, we have 50 state laws.
Okay. All right. So how come you have not enrolled to be called to the bar in Ghana?
Well, because I don't live here most of the time. And if I moved here, then I might consider applying. But I must say that I'm not the least bit impressed by what they do here in terms of how they call people to the bar. I believe it's something that we really need to sit down and re-engineer because it's completely obsolete and it is more or less impeding progress.
Well, what is wrong with it and what do you think we must do?
Well, you know, the model that they have today is the same model that Geoffrey Bing put in place in the early 60s or late 50s. You go to a university. At that time, there was one university, University of Ghana. And then you study law, you get your law degree. Then you go to the School of Law. The School of Law was supposed to be a finishing school. You were not going there to study substantive law. You were just going there to study how lawyers actually practice law in the courts. So you learned how to do drafting, you learned how to do escrow accounting and stuff like that. Very short course, and after that, you are called to the bar. Now they've maintained this School of Law and expanded the courses that they can teach, even as the number of universities granting LLBs have also increased. So right now, I don't know, I think there are about 12 or 13 schools offering the LLB. And then when they are all done, they are all trying to go to the One Ghana School of Law to do sometimes courses that they should be doing at the universities. So for instance, I know they have to go to the School of Law to do evidence, to do civil procedure. And the LLB in Ghana differs from the LLB in the rest of the world because it's the only LLB that you can get without taking evidence, without taking civil procedure.
Really?
Yes. And why is that so? That is so because the people at the General Legal Council have decided that those courses, evidence, civil procedure, criminal procedure, and so on, should be taught at the Ghana School of Law. And they haven't justified why Ghana School of Law is the only place that these academic courses, these are not professional courses, these are academic courses, why should these academic courses be taught at the Ghana School of Law? Nobody has justified that. And so we have two problems. One, people are getting the LLB without being exposed to important courses like civil procedure and evidence. And two, after getting the LLB, they are being denied the opportunity to go to the Ghana School of Law to study evidence and so on. So we have a problem where we have a lot of LLBs who cannot continue to get certification to be called to the bar. And then we have the Attorney General's Department and other departments in the country looking for lawyers that they can't find. I mean, it's almost bizarre. If somebody was watching from afar, you would think we are crazy. Because here is a system, here's a country that badly needs lawyers. And there are about 12 people, 12 old people sitting there deciding, I'm not going to let you guys have the lawyers that you need. And the rest of the country is sitting, I think we are just sitting there watching. Occasionally, we'll talk for 2 days and then we'll move on. That has to change. Fundamentally, we need to grab this problem, solve it. It can be solved. It can be solved quickly, and it should be solved quickly.
They say that people like you who hold this view want standards and quality to be sacrificed.
I don't know how one can come to that conclusion when the model that we are advocating is available in the rest of the world. Number two, we have the Institute of Chartered Accountants of Ghana. 3, we have the Medical Licensing Board in Ghana. 4, we have the Ghana Pharmacy Board in Ghana. All of these professions that I mentioned in Ghana use the model that we are talking about. Are they suggesting that standards and quality are poor in the medical profession, in the pharmacy profession, in the nursing profession because they have chosen this model that makes sense? Are they suggesting that the obsolete model that they are using is producing high quality lawyers? Based on what? What is the research that they have done to show that their model is producing higher quality lawyers? The best way to test their hypothesis is to allow the universities to also produce these people who can take the bar exam. Then we can compare the performance of the university students with the performance of the students who go to the Ghana School of Law. Then we can say, hey, the universities are not doing very well when we look at the performance of the bar exam, or the Ghana School of Law is not doing very well when we look at the performance of the on the bar exam, and therefore let's shut down the Ghana School of Law.
So let me ask you something. This is one country, Ghana. You have used the medical profession as an example. Both medicine and law started off with just University of Ghana, Legon, and then they go through Kolebu. Law goes through Makola. As we speak today, we've gone, for public universities, we've gone beyond Legon to having KNUST, UCC, UDS, UHAS in the Volta region. And then when it comes to even private, we now have 2 medical schools. The one at Teshi Nungwa, Prof Kwaku, and then there's one in East Legon. And they have all been certified and they are training doctors. However, when it comes to law and medicine all started same way. When it comes to law, what we've done is that for the LLB, we have accredited more institutions. But when it comes to the professional, it's still the same one, Makola. Now, added to this is, I look around the Commonwealth jurisdiction, and I even look at a place like the UK, where you have the option of studying or training to become just a solicitor, and then also deciding to become a barrister. In Ghana, we have combined both. And so you can't do anything with your LLB as far as law is concerned. How come that as a country we've made some progress with medicine, yet with law we are stuck the same way?
Well, because of undue deference that we give to the General Legal Council. Because you see, when you look at the General Legal Council, the chairman of the General Legal Council is the Chief Justice. And then there are also 4 of the senior members of the Supreme Court on that council. So even Parliament gives them an undeserved deference, because what they are doing is completely ridiculous. I mean, I've chosen my word rather carefully, because I could even say something worse. And everybody knows that. Everybody in Parliament knows that. Everybody in the executive knows that. Everybody in the country knows that this model is not working. But who is going to be bold with power? I mean, I don't have power. I can say what I want. But the people with power, the people in Parliament, they need to say boldly, this model is obsolete and we are going to rip it apart, and then do so without caring about whose ox is God, because the interests of the students are more paramount than the interests of respecting or showing deference to these members. The second problem that we have is, I don't really like this idea of Supreme Court justices sitting on administrative bodies.
Why?
Because if you sue the administrative body for violating the Constitution, for instance, you have to go to the Supreme Court. And then you have...
This happened a few times.
It's happened. I have the case. I sued the General Legal Council at the Supreme Court and won, by the way. But even though I won, they really gave some consequential orders that really negated the victory that I won.
Really?
Yes. Because, I was saying that...
What was your case?
My case was that the examination, the entrance examinations and the interview, this is I think in 2015 or so, were unconstitutional because the legislative instrument did not allow it. And once you have a legislative instrument, the legislative instrument can only be amended by the process specified in Article 11.7. You cannot amend a legislative instrument by fiat. And the Supreme Court said yes, but nevertheless, let the student go and do the exams because we want to apply this ruling prospectively.
Oh.
And that prospective doctrine was even poorly explained and conceived. But that's one of the problems you have when the Supreme Court members are also sitting on the administrative bodies. Then when you go and sue them, people who sit on the panel are a little bit antsy. Are we going to say the most senior members of our panel, of our court, sat on this administrative body and did something that was unconstitutional? It is a conflict that should be avoided.
All right, okay. Well, so we keep pushing. Now, I started reading from you when you started pushing a lot of diasporan issues, looking at our constitution and saying things to the effect that you thought that there were things in our constitution that were not right, or that you thought that some of the interpretations that were given to things in the constitution were not right, especially the right to vote for diasporans. That's when I started reading from you, and from then on, you've been very consistent. You've taken many cases to the Supreme Court, all with respect to constitutional interpretations and all that. What led you into this advocacy, and how successful has that been?
Well, remember we talked about my school days and being involved in student politics.
Yeah.
That was all about restoring the Constitution, which had been overthrown on December 31st, 1981. We resolved, at least some of us resolved, that if we are fortunate and the Constitution is restored, we are going to do everything within our power to defend it, to preserve it, to uphold it. So I pay very close attention to whether or not the strictures in the Constitution are being followed, or whether they are being violated. And when I see any violations, I'm very quick to point it out. One of them, as you have mentioned, is the way the country and recently the Supreme Court has interpreted Article 94(2)(a). It's completely wrong, and I think we are going to be talking about it.
Let's do it on it.
Let's do it now.
Yes.
Yeah. Now, if you look at Article 94(2)(a), it simply says, let me read it. A person shall not be qualified.
We'll put it up for you.
Okay.
Now go on.
Yeah. A person shall not be qualified to be a member of Parliament if he owes allegiance to a country other than Ghana.
Right.
And this is
94(2)(a).
Article 94(2)(a) of the Constitution of the Constitution 1992.
Right.
The simple question before the Supreme Court was, well, what is the meaning of the phrase "owe allegiance to a country other than Ghana"? That was the simple question. And the Supreme Court reasoned that since citizens owe allegiance to countries, then it must follow that Article 94(2)(a) is talking about dual citizens. That's the reasoning, because they said allegiance and citizenship are interwoven and cannot be decoupled. And so when Article 94(2)(a) says a person who owes allegiance to a country other than Ghana, then Article 94(2)(a) must have been talking about dual citizenship. Now that is strange reasoning, Randy.
Why so?
Because the first thing that you want to do when you are interpreting a constitution is to understand the history. If you don't understand the history, you are not really interpreting the constitution. You are just doing English comprehension. And English comprehension is very, very different from constitutional interpretation. Now, this Article 94(2)(a) predates the allowing of dual citizenship.
Okay.
So when the Constitution was promulgated in 1992, dual citizenship was not allowed. So it absolutely makes no sense to say Article 94(2)(a) was directed at a status that was not even allowed.
Or contemplated that.
Or was not even contemplated. So if that is the starting point, if you understand the history, then they could have avoided this problem. The second thing to note is if you go to Article 8 in the Constitution,
yes.
Article 8 in the Constitution is an amended article.
Yes.
So it came into the Constitution in 1996.
Yes.
And in 1996, when they wanted to talk about dual citizenship, they did not say a person who owes allegiance to a country other than Ghana. No, what they said was a citizen of Ghana may hold the citizenship of any other country in addition to his citizenship of Ghana.
Okay.
So Article 8(2) tells us that in the Constitution of Ghana, when we want to talk about dual citizens, this is how you say it: a citizen of Ghana who holds another citizenship in addition to his citizenship of Ghana. Then Article 8(2) then goes on to say, Randy, without prejudice to Article 94(2)(a). Okay, so it's saying, well, we are going to put in this new article, but we are going to remember that there's an existing Article 94(2)(a), and without prejudice to Article 94(2)(a), no citizen of Ghana shall qualify to be appointed as a holder of any office specified in this clause if he holds the citizenship of any other country in addition to his citizenship of Ghana. Then they list the positions: ambassador, secretary to the cabinet, chief of defense staff, IGP, and so on, and then any office specified by an act of parliament. Then subsequently, parliament added chief justice and so on, chief justice, director general, chief fire officer, and so on and so forth. So in the Constitution of Ghana, there are two independent sources of disqualification. One is allegiance-based, Article 94(2)(a), and then two, dual citizenship-based, which is Article 8(2). And they tell us that if you are a dual citizen, you cannot hold certain positions. Why? Because dual citizens owe citizenship-based allegiance to a country other than Ghana. Independent of that, if you also owe allegiance to a country other than Ghana, as defined in Article 94(2)(a, Article 94(2)(a) is not citizenship-based. And we know that because Article 94(2)(a) was inserted in the Constitution at a time when dual citizenship was not even allowed. So there's a citizenship-based disqualification in Article 8(2) and a non-citizenship-based disqualification in Article 94(2)(a).
So let me just understand this. What you're saying is that for 94(2)(a), there's a possibility that a person holds only Ghanaian citizenship, but could hold allegiance to a country other than Ghana.
Yes.
Without necessarily holding a citizenship of another country.
Absolutely. And that's the reason they have 94(2)(a).
Yes.
And they explain, when you go and you read the memorandum accompanying the 1969 Constitution, the Constituent Assembly's work, they explain that they have this allegiance clause because they want to disqualify people in occupations that are incompatible with serving as MPs.
So that is in the Constituent Assembly's work.
That is there. They didn't do any research. If they did any research at all, they would have seen.
Yeah, but that is what explains the reasoning behind the enactment.
Yes, absolutely. That's why I'm saying, if you start reading the Constitution as if you are doing practical English.
For the benefit of our viewers, give me a classical example of allegiance without citizenship.
Well, let's give the most basic example.
Yes.
When we swear in a president,
yes,
the president takes an oath of allegiance.
Yes.
That is not an oath of citizenship.
Yes.
That is a job-related oath.
Yes.
The justices of the Supreme Court,
yes,
they swear an oath of allegiance.
Yes.
That has nothing to do with citizenship.
Yes.
If you join a military, you will swear an oath of allegiance. That has nothing to do with citizenship. So let's say you are a Ghanaian and you are resident in the United States. You can join the U.S. Army.
With a green card.
With a green card.
Okay.
And with that green card, you would swear an oath of allegiance.
Okay.
Even though you are not.
So that oath of allegiance is to the United States?
It's to the United States because
okay,
you are serving in the U.S. Army.
So although you hold only a Ghanaian citizenship, you have sworn allegiance to a country other than Ghana?
Yes.
Okay.
And then I know you have been around for a while, so you may recall the swap of Susudis.
Yes.
And Pearson,
yes,
Aduse,
yes,
and
yes,
others.
Yes.
Susudis was accused by the U.S. of extracting information from a CIA lady. And there was a question of what to do with them. So there was some mutual exchange. The U.S. had some people in Ghana working for them.
Yes.
And
Ghanaian citizens.
Ghanaian citizens, not dual citizens, Ghanaian citizens. Those people were described as CIA assets. So the U.S. was willing to swap Susudis for about 8 Ghanaians. If it's these type of people and the allegiance that they owe, that constitute a threat to their being in the legislature. That is why Article 94.2a was inserted. Article 94.2a could not have been inserted because of citizenship. Because citizenship, dual citizenship, was not even allowed. Any homework, if they had done any homework, they would have avoided the type of interpretation that they gave.
Let's get back to exactly what the Constituent Assembly said.
Okay.
So that will be what? The spirit behind 94.2?
Yeah, 94.2.
Okay.
That's the reasoning
yes.
behind 94.2.
So what did the Constituent Assembly say for this?
They said
yes,
they are advocating that people who are in occupations that are incompatible, naturally incompatible with serving as legislatures should be disqualified.
Okay.
That is the reason.
Okay.
And the examples of, I've given you examples of that.
So you're saying that per the construction and the rationale which is founded in the Constituent Assembly's work, what was contemplated here was the situation where there are people who hold only Ghanaian citizenship, yet they owe allegiance to countries other than Ghana.
Precisely.
And that's the examples that you've given.
Precisely.
That, for example, there could be a Ghanaian who is enlisted into the U.S. Army or the British Army. They don't need to hold British citizenship to be in there. But to be enlisted, they swear allegiance.
Precisely.
And this is what the Constitution was contemplating.
In Article 94.2.
Okay.
And it is also very easy to see because the language itself is a term of art.
Right.
It is used in the constitutions of many countries, especially Commonwealth countries, because it was something that the British exported to all their colonies. So if you look at the Australian Constitution, which the court cites in the judgment, they cited Section 44I. And Section 44I is important. I hope you can show it to your viewers.
Section
44I of the Australian Constitution.
Yes.
It says any person who is under any acknowledgement of allegiance, obedience, or adherence to a foreign power, comma. That comma is important because The first point is under any acknowledgement of allegiance, obedience, or adherence to a foreign power. That is something very similar to our Article 94 2A, because this is saying if you owe allegiance, they add things. If you owe allegiance to a foreign power, you follow?
Yeah.
Then they go on to say, or is a subject or a citizen. So that is another wing. A subject or a citizen of a foreign power. That is our Article 8.
Yes.
Because that's dual citizen.
Yes.
And then there's a third wing, or entitled to the rights or privileges of a subject or a citizen of a foreign power. That is the third limb. So there, in this section 44I, there are three limbs. One is a person who is under any acknowledgement of allegiance. Our court will say, well, once you're under an acknowledgement of allegiance, then you are a dual citizen. So our court will say, Australian section 44.1 is saying any person who is a dual citizen or a dual citizen or a dual citizen. Merely because they are seeing the word allegiance. And that's because they are unable to reason that one could owe allegiance for reasons unrelated to citizenship. What this Australian section is telling us is one can owe allegiance, that's the first limb, and then one can owe allegiance because they are a citizen, that's the second limb, and then they even have a third limb. They say one can owe allegiance because one is entitled to the rights or privileges of a subject or a citizen of a foreign power. They cite this case wrongly because if they had actually studied the case specifically says, let me see if I can quote from it.
Yeah.
But the case specifically tells us that they are dealing with the second limb. They are dealing with the second limb. Let's see here.
Which is about citizenship.
Which is about dual citizenship.
Okay.
The person, Gallagher, who was being challenged, whose citizenship was being evaluated, was accused of having dual citizenship. She didn't even know that he was a citizen of UK, because under the UK law, many people born in the colonies were automatic citizens. In fact, if we apply the law the way the Australians applied, we would disqualify everyone who was born before 1957. Because everyone who was born before 1957 is a UK subject or a UK citizen. But here, if I can see it, it says here, it says the words subject and citizen of a foreign power, which appear in section 44I, connote the existence of state of affairs involving the existence of a status or of rights referable to such a status under the law of the foreign power. Then they go on to say the second limb of section 44I is concerned with the existence of a duty by a person to a foreign power as an aspect of the status of citizenship. So the case that they cited should have told them two things. Owing allegiance is different in constitutional law from being a dual citizen.
I've heard people say that anytime you refer to 94.2, you should read it jointly with Article 8. And that if you do not do so, you miss the point.
Yes, absolutely. And that's the point I'm making. Because Article 94.2, when you read it and you start thinking it's dual citizenship, then when you go to Article 8 actually describes dual citizenship. It tells you in our constitution, if we want to talk about the dual citizen, we call them a citizen of Ghana who has the citizenship of another country. So that is the term. And if you don't find that term, then don't force to make citizenship the issue, because citizenship is not the issue.
So the point you're making is that if the framers of a constitution intended for 94.2a to refer to dual citizens, they would have clearly stated that a person shall not be qualified to be a member of parliament if he holds the citizenship of another country.
Yes,
is
absolutely.
that the point you're making?
Well, that's not the point. That's the point I'm making.
Yes.
But more important, it wouldn't have made any sense because dual citizenship was not even allowed.
Yes.
So in 1992, if you were a Ghanaian and you had a citizenship of another country, you automatically will lose your Ghanaian citizenship.
Yes.
This Article 8 that you are reading was inserted in 1996.
Yes.
And in inserting it, they specifically added positions that dual citizens could not hold.
Yes.
And they didn't add the positions in Article 94. They didn't. They actually said without prejudice. That is telling you they understand the difference between Article 8 and Article 94.2, because they are saying if you are a dual citizen, then you automatically you cannot hold all these positions. You cannot be an ambassador, you cannot be a secretary, and so on. But if you are a dual citizen who is also spying for another country, then you cannot be qualified to be in parliament.
So what you're saying is that the 8.1, enlisting the offices, including the amendments that were made by Parliament when the bill was presented to them, did not include the office of a member of Parliament.
Yes.
And that if the intention was to include that, it would have been added.
Absolutely.
And so your point is that interpreting 94.2 to include the office of a member of Parliament is wrong.
It's absolutely wrong, because that is, you are just forcing it. The Constitution doesn't say that. You are just forcing it because you have misconstrued the meaning of owing allegiance to a country other than Ghana as used in Article 94.2a. In constitutional law, when we want to say a citizen owes allegiance, right? We don't say it because just saying citizen, it's inherently, the notion of owing allegiance is inherent in citizenship itself. When it is spelled out that you owe allegiance to a country other than Ghana, then that is a different term. That is a different term. And we can see that from the Australian Constitution itself. The other thing about the Australian Section 44I, I want to raise this right here because there was another problem there. It says, if you look at the very last sentence, it says, such a person shall be incapable of being chosen or sitting as a senator or a member of the House of Representatives. You see what they've done?
Yeah.
They have two things. You are incapable of being chosen, or you are disqualified from sitting as a senator. The court relies on the dates in the Australian case to justify the date it's set for our Article 94.2a. But our Article 94.2a merely says a person is not qualified to be an MP. That is referring to sitting as an MP, not incapable of being chosen as an MP. We don't have anything which says a person is incapable of being chosen as an MP if he owes allegiance to a country other than Ghana.
Now, how do you reconcile the statement you're making with PNDC Law 284?
PNDC Law 284 is also very clear, because if you look at PNDC Law 284, Section 9.1.
Yes.
If you look at Section 9.1, Section 9.1 says what?
A person shall not be qualified to be a candidate for the office of member of Parliament unless he is a citizen of Ghana, has attained the age of 21 years, and is a registered voter, resident / haul from, paid all taxes or made arrangements satisfactory to the appropriate authority.
Very good. Stop right there. Yes. So that is the Zaneto case.
Okay.
You are not qualified to be a candidate. You see?
Yes.
Qualified to be a candidate.
Yes.
Now, if you go to NITE2 is now going to be talking about Article 94.2 and read Article 94.2.
So it says that the 2842 says a person shall not be qualified to be a member of Parliament if he A, owes allegiance to a country other than Ghana.
Precisely. Okay. So you see the distinction between the two. Okay. One is you are not even qualified to be
a candidate.
That is the Australian version of you are incapable of being chosen. That is what 94, that is what Section 9.1 is saying. And then when it goes to Section 9.2, it says you are not qualified as an MP. You are not qualified to
sit. If you owe allegiance.
If you owe allegiance, however you define it.
Are you suggesting that by virtue of the 2842, a person who owes allegiance to a country is not disqualified from being a candidate.
No,
but it's only disqualified from becoming a member of parliament.
Yes, that's what it says, right? I mean, I'm not saying it. I mean, anybody at all can read it. The only thing I've done is I've highlighted a candidate.
So the point you're making is that if the intent of the two was to disqualify those who owe allegiance from becoming candidates, it would have said so expressly.
Absolutely. Absolutely.
So what do you then say to those who say that becoming an MP is not an event, it's a process? It starts from somewhere. So you cannot just be speaking about when the person is elected, announced, or when he's made a candidate by the Electoral Commission, or when he's sworn in Parliament. But it must be from when he starts the process of wanting to become an MP.
Then they should rewrite the Constitution and make it similar to what we have in Section 9.1, or they should use the Australia language, which says you shall be incapable of being chosen. But you cannot just make it up when the Constitution doesn't say so.
Is that not what the Supreme Court has done by its ruling? By perhaps identifying that perhaps there are some ambiguity or mistakes with the drafting, and therefore it has used these decisions to clarify?
No, the drafting is perfect. Those who wrote PNDC Law 284 are actually very smart, because they took the Constitution and they distinguish between Article 94.1 and Article 94.2. If you read Article 94,
well, they would have done this before the Constitution.
Yeah, well, no, okay. Yeah. Well, if you look at Article 94.1,
yes,
it says a person shall not be unless. Mm-hmm. And then if you look at Article 94.2, it says a person shall not be if. Mm-hmm. The unless and if, these are not random words. Mm-hmm. Unless means you are not even eligible. You are not eligible to be a candidate. Mm-hmm. If means we don't want you to sit in our parliament if you are a bankrupt or you owe allegiance and so on and so forth. So the words matter. If the words do not matter, then we really don't even have to talk about constitutional law, because we live in a society where judges make the rules. And again, yes, I want to stress that the court justifies its timelines by referencing the Australian case. But that was wrong, because the Australian case was dealing with the phrase which says shall be incapable of being chosen as an MP, which is very similar to our Section 9.1.
Okay.
But our law on allegiance kicks in when you are about to enter MP. And then there is a very important section in the representation of the people's law, the PNDC law 284, section 20.
Yes.
If you look at section 20,
yes,
it tells you, look, don't cancel elections if at the time of the election a person is qualified to run.
So section 20 says grounds for cancelling election results. The election of a candidate shall be declared void on an election petition if the High Court is satisfied that the candidate was, at the time of his election, a person not qualified or a person disqualified for election.
Elections are expensive. Don't go and remove someone and go and do a by-election and bring back that same person. So if at the time of the election, the person is qualified, let him go. You may fine him for not submitting a form on a timely basis, or you may reprimand him, but don't set aside the voice of the people, because the voice of the people really happens to be the voice of God. That is what Section 21D is telling us, that, look, elections are expensive. So even if somebody was not qualified before the election, but he shows that at the time of the election he was qualified, then don't cancel the election. You can find some other remedy. You can find some other way to...
But this was available to the Supreme Court. Yeah, the Supreme Court believed that he had to be disqualified.
Yeah, I mean, look, I knew the Supreme Court was going to disqualify him long ago.
Why?
Because if they are not going to disqualify you, they won't put an injunction on you for 1.5 years. There is no court in the world that will injunct an MP for 15 months. He said, look, representation is at the heart of what we do. And if you remember, there was an earlier case where the Supreme Court was even saying that even in particular decision, we shouldn't disqualify an MP from making a decision just on one decision in Parliament. It's so important that a person who is a deputy speaker should be allowed to vote. That is how important representation was to the Supreme Court at that time. But in this case, representation...
That was recent. That was on the Joe Wise issue.
Yes, absolutely.
Yes.
But on this other case, representation was no longer important, and they put an injunction on the guy for 15 months. As long as they were willing to put the injunction, then reasonable people should have known that this is going to be the outcome. By the way, look at what the court said. The court said Article 94(2)(a) means somebody who has dual citizenship, and that person should file his papers or should show that he has renounced his citizenship at the time he files the nomination. How is that different from what the High Court said in Cape Coast? That is just the same thing that the High Court said.
Yeah.
So if that is all the court was going to tell us, then we should have, stayed with the High Court decision. This thing here, other than all the mistakes that anyone can pick up, really repeats what the High Court judge said. And strangely enough, the defendants, Chikwesin and his team, tried many times to get the Supreme Court to interpret Article 94(2)(a). All of the last decision that I saw was a 5-2 against them. But when the plaintiff decided that he was going to seek the meaning of Article 94(2)(a), the plaintiff was welcome. Not only was the plaintiff welcome, they welcomed the plaintiff by injuncting the MP. And then the injunction was left in place for almost 15 months. And then after 15 months, they came to tell us what the High Court told us. By misinterpreting Article 94(2)(a), by ignoring the statutes, the PNDC Law 284, by misapplying Australian case law, and by forgetting that Article 20, PNDC Law 284-21D tells us don't cancel elections when at the time of the election the person is qualified. So that is the big problem.
So where do we go from here? This is a decision of the Supreme Court. It has far-reaching implications. I mean, this is a precedent. How do we go around this?
Well, there are two ways. One, a little bit optimistic, the other more realistic. The little bit optimistic will be for the defendant. And then when you file for review, raise all these issues that we are raising.
What was the outcome of the initial one in terms of the voting? Was it unanimous?
It was unanimous.
So why would he go for a review if it was unanimous?
Well, you assume that you are going to talk to people who are honest. And if you make a solid argument, they would accept.
But you would only have two persons other than those who had the initial issue.
Yeah, but those who had the initial issues can change
their
your
mind.
Arguments and say, oh, wow, well, we missed that because Article 94(2)(a) predates dual citizenship. So our holding that allegiance is interwoven with citizenship is wrong on its face. On its face, it's wrong. It cannot be correct because Article 94(2)(a) had an independent existence before the arrival of dual citizenship. Number two, in the Constitution itself, there's a way that we talk about dual citizens. We say a citizen of Ghana who has the citizenship of another country. So that is dual citizenship. A person who owes allegiance is a different concept. In law, we have a principle called the principle of meaningful variation. Third, the Australian case that we cited it wrongly. In both allegiance and citizenship, we got it wrong. And in the timing, we got it wrong as well. Four, we have to wrestle with modern concepts of citizenship. Nobody today thinks about citizenship in terms of subjects and allegiance and all that. People think about citizenship in terms of rights. That is why in Sierra Leone, in Nigeria, they've held that you cannot have a citizen and tell that citizen that he cannot go to parliament. Because going to parliament is at the heart of representative government. And if you have, I don't know whether the court even tried to find out how many people will be affected by this decision, but by my estimates, there are about 10% of the people who are dual citizens. That would be 3 million people. So you're going to tell 3 million people that they are not eligible to go to parliament. And mind you, if you are not eligible to go to parliament, that disqualifies you from many other things. So for instance, you cannot be on the executive as well. You cannot be on any constitutional commission. So for instance, the EC, the NCC, and so on. You cannot be a founding member, a leader, or even an executive member of a political party. So those are the considerations. The second one is to amend the Constitution, to repeal it, to repeal Article A2 and Article 94(2)A, which is what we have been working on, advocating. Fortunately, there seems to be bipartisanship around that issue. The Council of State.
Is that your private member's bill?
That's a private member's bill, yes.
Okay.
Written by Kennedy Osei Nyakun.
Yes, the MP.
Yeah, the MP from Swedru. So there is some bipartisanship around that. The president supports it. Ex-President Mahama supports it. The NDC caucus supports it. NPP caucus supports it. So let's come together, learn from this experience, repeal it, and then move on as a nation. Nigeria, Sierra Leone, UK, US, Canada, and a variety of countries allow their dual citizens to participate freely in their parliament and in other things, and nothing wrong has happened to those countries.
Now, there's something. You sign off a lot of your or almost all your writings on social media with SAL is still the cardinal sin of the Fourth Republic. We saw an administrative directive by the Electoral Commission on, I think, the 5th of December 2020, asking the people of Santrofi, Akwafu, Lekpe, and Lolobi to vote in only the presidential election or the parliamentary election. We have some 18 months or so to go for the end of this particular term as far as Parliament is concerned. And from all indications, the Electoral Commission has even indicated that that will only feature for 2024. That's the Parliament of 2025. And you keep making the point that is a cardinal sin. It appears that the rest of us don't see it as a cardinal sin. Doing some research on it recently, I saw an urgent question asked of the Attorney General. And in Attorney General's response to Parliament, he makes the point that he thinks that that decision was wrong, especially a decision to create the new district, which then led to the SAL situation. And he provided some ways of remedying the situation, but that's where it's ended.
Yeah, I mean, that's another example of serious things that we don't take seriously in the country, because there's no democracy anywhere in the world where some of the people can be disenfranchised and then nothing happens. But in Ghana, it's par for the course. Even in this case that we are just discussing, the Asinov case, the Electoral Commission refused to go to defend its decisions, because the Electoral Commission should have gone to explain why it allowed Kwesin to run.
Especially when there was a petition.
Yeah, the Electoral Commission would have said, I was following the law. I was following PNDC law section 9(2). And maybe that would have changed the mind of the court. But they didn't show up. And they are not held accountable. The Electoral Commissioner is a duty bearer. Whether the Electoral Commission likes the candidate or not, whether he agrees with the candidate or not, if the work of the Electoral Commission is questioned, it has a duty to go to court to explain that. And if it doesn't go to court to explain that, then the Electoral Commissioner must be held accountable, including even initiating removal proceedings, because that's the only way that you are going to get these duty bearers to do their job. And the same thing with SAL. I mean, SAL is dead. Nobody says anything. But the reality is we've disenfranchised people, and we have not held anyone accountable for that mistake that should never have happened.
Did the Electoral Commission have any power, either under the Constitution or any LI or CI to have taken the decision that it took on the 5th of December?
No, absolutely not. It was by fiat. It was by fiat, because it had no power, and it probably believed that if it did it, nothing would happen, and we're proving them correct that nothing has happened.
But also with the government, knowing very well that there are consequences of creating a new district, because we've said that no constituency shall straddle 2 districts. And so knowing the consequences of creating a new district out of an existing constituency, we knew the implications. And we knew that taking that decision with some 4 months or so to an election, this would be the implications. And yet the government went ahead?
No, I don't think that would be the implications. I mean, if you have only 4 months to go to elections, then regardless of what the government is doing, as the independent electoral commissioner, you are fixated on making sure that everyone in the country belongs to a constituency and they get to vote in that constituency. You cannot let the government be influencing what you do. Otherwise, the government will merely go to places where it doesn't have support and start creating all kinds of districts 2 weeks to the election. And the electoral commission say, the government has created a district, therefore don't vote. That doesn't...
No, I'm saying that to the extent that the practice is that, or the law is that, no one constituency shall straddle 2 districts. To the extent that that is the situation.
Yeah.
Now, if a government, on the basis of its power, decides to create a new district and sends it to Parliament and has the numbers to pass it through, and therefore has created another district out of an existing constituency, which means that parts of the district will be in another constituency, and therefore you'd have a constituency straddling 2 districts, which is against the law. What does the Electoral Commission do?
Well, the solution is simple. If there is adequate room, adequate time to create the constituency to reflect that district that has been created, then you do that. But if there's no room, then you freeze your electoral map and create the constituency after the impending election. Otherwise, you are going to encourage the government to act opportunistically by creating these districts, which then upset the electoral map. So the electoral map, at some point, should be frozen because there's no time to create new to create new constituencies. So you could go ahead and create all kinds of districts, but once we get to that time, no new constituencies will be created. That's the solution.
All right, Prof, let's end on this one. The ROPA. Where are we?
Well, the ROPA, of course, it's already law, so it comes to just implementation. And I think, if I recall correctly, the Electoral Commission started to do something about it before the COVID. And so the COVID may have slowed the process. I don't know where they are now, but one of the things that we may want to look at is to create overseas constituencies. So let's say you may give North America 2 constituencies and Europe 2 constituencies and so on. So that people, when they vote, they'll be voting for an MP to come and represent those constituencies. And then spend some time to work through how we are going to vote for president. The start.
Would you be expecting those people to vote for only an MP and not a president?
On the pilot basis, as a start.
Okay, so you think we must pilot it?
I think when the project is so big, if you go in full strength, you may run into unexpected
Because I've heard people who make the point that, look, if you're going to do ROPA, then every Ghanaian living everywhere must be given the opportunity.
Yeah, absolutely. No problem with that. But that's what I'm saying. It's a very big project.
It's an operational nightmare.
So let's start with the pilot and then learn from that. Tweak it. So maybe by 2 election cycles, then we figured it out, and then we can do the full-blown thing where everybody is voting and everybody is voting for president. But in some of these countries, like Senegal, they've created overseas constituencies, and then there's not a lot of fight because people don't think you are going to dilute their constituency or whatever. You guys are voting for your own MP. I think people can live with that. And then from there, we move on to bigger things.
All right. So, Prof, I'd like to thank you for joining me on the show. Thank you so very much. We've done quite a number of Zoom interviews, but today we've had you here in the studio, and I've really enjoyed it.
Thanks so much, Randy. It's good to come to your luxury studio and to talk to you.
Yeah. So thanks, Prof. And I'm sure that anytime I'm in Florida, I'll get in touch.
Thanks.
All right.
Don't be a stranger.
Okay.